Ever buy something online, like totally convinced it was one thing, and then that package arrives and you're like, what is this? Turns out mix-ups happen in contracts all the time, and today we're diving into those oh no moments, specifically mistake and excuse in contract law.
And yeah, these aren't just legal loopholes. They're about fairness, risk, and sometimes whether someone's really stuck with a deal gone wrong.
And to illustrate, we've got some pretty colorful cases from actual law school casebooks. Get ready for some serious legal reasoning, folks. First up, let's talk about Rose.
Rose.
Yeah, Rose the Cow, star of Sherwood v. Walker. It's a classic.
Ah, right. The case where a cow, sold for practically nothing because everyone thought she was barren, suddenly becomes a very valuable breeder.
Imagine thinking you're getting hamburger and ending up with, like, a whole herd of prize cattle. But seriously, this wasn't about anyone trying to pull a fast one, right? It was a genuine mistake on both sides. So, what makes this case a legal landmark?
Well, the court in Sherwood v. Walker said it wasn't just a mistake about some quality of the cow, like, oh, she's got a limp we didn't notice.
Yeah.
This was about the very nature of what was being sold. They called it a mistake about the substance of the thing.
Substance, huh? So Rose's hidden fertility was a deal breaker, legally speaking. But how do courts draw the line between a Rose situation and, say, someone buying a used car that turns out to need some work? We've got another case, right? Anderson Brothers, Corp v. O'Mara, something about a dredge.
Yeah, a dredge. Basically a huge underwater digging machine. The buyer in that case needed it for one specific type of job, digging these wide canals. But the dredge was designed for narrow trenches. Big difference. He tried to claim mistake, but the court didn't buy it.
So, no takebacks for bad research. Should he have brought a tape measure underwater? I mean, how much due diligence is enough when you're buying something that complex?
Right. Well, the court said that unlike Rose's, surprise fertility, the dredge's capabilities were all out there. The seller even had a whole history of using it for certain jobs. The buyer had every chance to inspect it, ask questions, do their homework, but they just didn't.
Okay, that makes sense. But that brings up another question that I bet a lot of our listeners have dealt with, right? What about those as-is clauses you see everywhere? Like, if you buy a house as is and then find out the roof leaks, or worse, the septic system is shot, are you just out of luck?
Pretty much. That's the gamble with as is. It shifts all the risk to the buyer. The seller is saying, look, this is what it is, take it or leave it. It's a powerful shield for sellers, especially with real estate.
So if there's one takeaway for our listeners so far, it's that.
Do your homework. Don't just rely on assumptions, especially with big purchases. A little inspection goes a long way.
Okay, we've talked about mistakes about the thing itself, but what about when some crazy stuff goes down after you've signed on the dotted line? Like, you book a killer band for this awesome outdoor venue, right? Tickets are selling like hotcakes, and then bam, a freak storm hits the city, floods everything. What happens to the contract then? Is everyone just out of luck?
That, my friend, is where excuse struts into the courtroom. It's all about whether something totally unexpected lets you off the hook, contractually speaking. And, your flooded concert example, perfect illustration. In fact, it reminds me of Taylor v. Caldwell, this case that literally went up in smoke.
Oh, no way. What burned down?
Picture this. A beautiful music hall, all rented out for this big series of concerts. Contract signed, everyone's excited, and then, through no fault of their own, poof, the whole place burns to the ground.
Oh, man, that's awful. But also, no music hall, no contract, right? Seems pretty open and shut.
You'd think. But Taylor v. Caldwell is famous for a reason. It gave us this whole idea of commercial impracticability. Basically, it's not just, is it impossible, but did something happen that no one could have seen coming that makes it crazy difficult or expensive to make good on the deal?
So, it's about the whole balance being thrown off, not just, oh, this is going to cost a bit more now. What if you booked that venue specifically for its outdoor garden, and then a hailstorm hits during your big event? Talk about damages, lost revenue. How do courts even measure what's impracticable versus just bad luck?
Yeah, it's tricky. Courts look at a ton of factors, but foreseeability, that's a big one. Remember when the Suez Canal got blocked a while back?
Yeah.
Global shipping nightmare. Huge case. Transatlantic financing.
Oh, yeah. Talk about a detour. Having to sail all the way around Africa instead of just through the canal. Those poor ships must cost a fortune.
Exactly. Costs were astronomical. But was the blockage really unforeseeable? That's what the court had to decide. Was it just a business risk they should have planned for? Or was it so out there that it justified tearing up the contract? And here's where it gets even more interesting. This wasn't just any old ship. The route directly affected the price of the goods they were carrying.
So it's not just about what's fair in some, like, general sense, but in the context of that particular deal, if having the Suez Canal open was key to them making a profit, maybe that hits different than if it was just going to cause a small delay.
You got it. But just when you think you've wrapped your head around impracticability, the courts toss in a curveball.
Yep.
Enter the Tice case.
Ooh, lay it on me. What's the Sight saga all about?
This one involves a worker, right,
Yeah.
who had diabetes and sadly had to have his foot amputated. Because of this, he couldn't do the very specific job he was hired for, claimed impossibility as his defense.
Oh, man, that's rough. But I'm guessing the court didn't just let him off the hook that easily.
They did not. As tragic as it was, the court said the amputation wasn't like a sudden, totally unpredictable event, like that fire.
Mm.
Because of his health condition, they considered it a risk that was, to some degree, foreseeable.
So a sudden act of God versus a pre-existing condition, even a serious one, two different bars for excuse.
Yeah.
Man, contract law is wild.
It is, and this is where it gets really tricky, right? Where do we draw the line? How much risk are people expected to shoulder? No easy answers, that's for sure.
All right, so we've covered cases where the what of the contract goes haywire, but what about the why? Like, you rent this amazing apartment specifically to be near that new train line everyone's talking about, right? Makes your commute a breeze. But then construction gets delayed for years. Your whole reason for renting is shut, but the apartment's still there. What then?
You've just landed on frustration of purpose. The contract's not impossible to perform. It's just pointless. And that brings us to Krell v. Henry, the case of the very disappointed coronation viewer.
Wait, someone rented a place just to watch a coronation? Talk about a royal enthusiast. What happened? Spill the tea.
So picture this. A gentleman, Mr. Henry, rents this flat, right? Prime location, overlooking the whole coronation procession route. Everything's set, then bam. The king gets sick, coronation's postponed indefinitely. Henry's like, hold on, I didn't rent a room. I rented a front row seat to history. Cries, frustration.
Wow. So did the court make him pay for a room he obviously didn't need anymore? Seems kind of harsh.
Surprisingly, no. They agreed the coronation. That was the whole point of the contract. The room itself was almost secondary. But, and this is a big but, how foreseeable was this cancellation? What if everyone already knew the king was ill?
Right. If it was a known risk, shouldn't that have been, part of the deal from the get-go? So is a canceled event always a valid excuse? Like, what if it was a local parade, not, a big coronation? Does that change things?
Exactly. Context is key. Like in Lloyd v. Murphy. World War II, right? Restrictions on selling new cars, throws a wrench in everything, car dealership tries to claim frustration. No new cars, no business, case closed, right?
Yeah, I mean, at the time, that must seem like a pretty solid argument. What did the court say?
Not so fast. They said, look, the lease, it wasn't that limited. They could sell used cars, parts, maybe even rent the space out temporarily. The war messed with their plans for sure, but it didn't totally destroy the point of the lease itself.
So it's not just about things being harder, it's about the whole reason for the deal just vanishing. And even then, no guarantees. Speaking of tough cases, what about that LCOA one? Something about energy costs going through the roof.
Ugh, LLCOA, a classic. This one shows how even the most airtight contracts can get blown up by global events no one saw coming. They had this long-term agreement to process aluminum. Price was pegged to a specific index. Then OPEC happens. Energy costs explode, but their index, it didn't budge. LCOA was losing a fortune.
Talk about a perfect storm. Sounds like the definition of unforeseen circumstances. So did they get out of the contract?
Not quite. The court, they understood the predicament, right? But they also had to think about the bigger picture. What message does it send if we just let people out of contracts whenever things get tough? So what they do? They got creative. They reformed the price, essentially rewrote that part of the deal to make it fair given this insane situation no one predicted.
Wow. The court stepped in and, modified the deal themselves. That's a bold move. Sounds like they were trying to walk that fine line between upholding contracts, but also recognizing, hey, sometimes life throws a curveball, and the rules need to bend a little.
Exactly. It all comes back to that balance.
Yeah.
Keeping contracts reliable, but also acknowledging that unforeseen circumstances, they happen. Sometimes what's fair isn't always crystal clear.
So what's the lesson here for our listeners? What can they learn from all these mistake and excuse cases? Seems like there's no magic formula, no one-size-fits-all answer.
You got it. Contract law is full of gray areas. These cases just underline how important it is to really think about potential risks, draft crystal clear agreements, and hey, maybe even throw in a well-placed what-if clause just in case. You never know.
And there you have it, folks. From a pregnant cow to a canceled coronation to sky-high energy costs, we've seen how unexpected twists and turns can turn a simple contract into a real legal head-scratcher.
So next time you're about to sign on the dotted line, remember, the fine print's important, but it's the what-ifs that'll really make you stop and think.